for the topic now today is to deal on the orders obtained on the grant of what? On the grant of divorce. They're like remedies, they're like effects of divorce, basically. So one of the first order is the decree nisi. A decree nisi is a temporary order. It's provided under section 37 of the Divorce Act. That is a decree what? A decree nisi. Basically, it is normally provided under what? Under the separation agreement, the judicial separation. The court awards a decree nisi. A decree nisi, its period is like for 3 months. It is like a separation, temporary separation by what? By court. That is the decree nisi, whereby it moves for a particular period of time, and its major emphasis it is that to see that married couples can come back to what? Can come back together. That is the decree nisi. Section 37 of the Divorce what? The Divorce Act. Then we have a decree absolute. A decree absolute is provided under section 37 clause 2 of the Divorce Act. A decree absolute comes after decree nisi. Once a decree nisi fails to bring out that reconciliation in the married couples, then court will grant what? A decree absolute. Once court declares a decree absolute, then there is no turning back. But remember, under decree nisi, marriage can come back together. The married couples can come back together under decree nisi. But under decree absolute, once court declares it, then divorce has happened. The couples cannot come back together. The only option they have is to get remarried again under decree absolute. We have the case of Neonje versus Neoje, 1967. Neoje versus Neoje. Under this case, court held that there is no power in Uganda for the court to abridge the 6-month period provided by the Divorce Act. Section 38 of the Divorce Act, between a decree nisi and a decree absolute, it is the period of 6 months. You get? So basically, to retract what I stated earlier, is that the period between a decree nisi and a decree absolute, it is a period of 6 months. You get? 6 months, whereby here that they grant that it must be a period of 6 months, then that period passes. When the period passes without any conciliation that has taken place, then court grants what? A decree absolute. But it cannot award a decree absolute without the time lapse of the 6 what? The 6 months. Those are some of the 2 orders. First of all, we have a decree nisi, we have a decree absolute. Then we have costs. Court can award costs to the petitioner. That is section 22 of the Divorce Act. You get? As I told you, this can be orders as well as remedies or effects of divorce. We have costs. Section 20 of the Divorce Act. The petitioner can be awarded what? Costs of the suit. Then we have alimony, pendant light. We have alimony, pendant light. You get? Alimony, pendant light, it is provided under section 23 of the Divorce Act. So alimony, pendant light, basically this, what you have to know or what you have to bear in mind is that here realize that under section 23 of the Divorce Act provides that alimony, pendant light shall not exceed a fifth of the husband's average net income in the last three months. That is to do with alimony, pendant what? Pendant light. But when you realize that you have alimony, pendant light, and you also have permanent alimony. Permanent alimony, pendant light, basically for it comes more so during the separation agreement, the mutual separation. But for permanent alimony comes after a decree absolute. But for alimony, pendant light comes during normally a decree nisi. But for permanent alimony, normally comes under a decree absolute once the marriage has been what? Dissolved completely. That is section permanent alimony provided under section 24 of the Divorce Act. You get? And for permanent alimony, it is normally made when marriage is dissolved under a decree absolute. But for alimony pendant right, it is normally done under decree nisi. And under permanent alimony, court considers the following: the wife's fortune and or economic standing, and the ability of the husband to pay, and the conduct of the parties. Those are the three things that court puts into consideration for it to award a permanent alimony to the what? To the wife. These two things are for the wife. Alimony is for the wife. You get? Basically, they say that also that there is a case of Helen Monica Barrett versus James Barrett. Here, the court held that the essence of the wife, you understand, the wife, alimony is for only the wife, not for the children. If the wife wants maintenance for the children, he must use another provision of law to ask for maintenance of the children. But following Section 24 of the Divorce Act that provides for alimony, which is permanent, it is normally for the wife only. Let's bear that in mind. It's for only. But if a wife wants to ask for maintenance for the children, then he will use a different provisions of what? Of the law. So basically, those are some of the orders that are obtained on the grant of what? On the grant of divorce. Those are some of the what? Of the orders. So just beg to continue to be on and subscribe to the channel, get notifications. Thank you for listening.